in this country, which is 1998. We're dealing with the Computer Misuse Act of 1990, which predates the existence of an iPhone by some 17 years.
So this is prehistory as far as computing and IT is concerned.
Absolutely. And we really have to find a way that we can try to keep up to date with the technology, with the legal arguments that we're running.
Well, this is the essence, I suppose, of this discussion, is that if we don't concentrate, organisations like Google have found ways of getting our data and using it in their own interest. It may not be malevolent, but it certainly isn't necessarily in our interest. Johnny?
Well, a future privacy policy for Google may look something like the following. What we collect, everything, when we collect it, always. Do you give fully informed consent? If yes, click yes. If no, don't use it.
Yes. Well, that's very difficult in a virtual monopoly provider of their service.
Ah, well, that's a different question.
Yeah.
Yeah. That is for me, and that links back to what we discussed with the care robots and the element of deception. One of the important changes that might come as we move from the Data Protection Directive to the regulation, that it takes account more of actual power differentials between people, that consent doesn't become any longer the sort of magical wand that you wave and everything goes okay. I mean, I talked about horses, let's talk about vampires. You might remember, obviously, once you invite a vampire in, it can more or less do in your house whatever it wants, as long as you don't invite it in, it has to stay outside. With these care robots that we discussed, with some of these other robots, you give, in a way, the invitation to come into your home. And that shouldn't mean any longer that as soon as they're in, they can do everything to you and to your data as they want, suck it out like a vampire. So this issue of is it really free consent? Is it informed consent? If I have to use a certain service because it simply becomes the standard, if I have to use an automated car because otherwise I won't get insurance, if I have to use a care robot because that's the only thing the NHS can afford any longer, then I think this issue of informed consent becomes very, very fragile and not good enough. And I think the new regulation will go a long way at addressing that.
I see. Well, I've got the image now of this handy vampire being invited in to provide a service. Talk me through how the algorithms work in this whole area. Is that where we have to concentrate the regulation? Mark?
I think there are two areas we need to focus on. The first one is the algorithm itself, and in particular the security of that algorithm. If that algorithm can in any way be tainted or tampered with from an external source, I think that creates a real problem.
Do you need to explain what an algorithm is? Would that help, do you think?
Well, an algorithm in its simplest sense really is just a way of calculating if X and Y then Z. Yeah. I mean, it can be as simple as that. I mean, obviously the algorithms we'll be talking about in these sort of contexts for artificial intelligence are far more complicated. But obviously, because these algorithms are very complicated and the information that's gone to make up the algorithms themselves are quite commercially sensitive, the chances of anyone really being able to understand what is in that algorithm is going to be very difficult. So these are, by their nature, very secretive sums or calculations.
What about Lillian Edwards' point that lawyers should be brought in at the beginning or while you're constructing the algorithm rather than after it's up and running?
I think lawyers should really be aware of their own limits, and we are very good at doing. we are very good at legal arguments, legal reasoning. We are not technologists first and foremost, and so I would be concerned that if the lawyers are brought in too early, that rather than encourage growth and encourage development, they end up sort of fettering or slowing that process down.
Would you agree with that, Johnny?
Well, we were talking about driverless cars. Lawyers are often seen as the speed bumps rather than the accelerator pedal, and whilst that's an unfortunate reputation, it's probably true. But just going back to definitions, I mean, an algorithm is really a repeatable procedure for achieving a result. There's nothing magical about it. It could be mathematical, it could be linguistic, it's just a set of steps that gets you somewhere.
Yeah.
Obviously, some of the algorithms are secret, but one of the real issues that arises there is of transparency. And we see this most commonly talked about in the context of Google search results. How do we know how it's magic juice to rank the one holiday company at the top and the other second? And what's the relationship between those listings and Google? And what happens when those listings contain data published by third parties which infringe other people's rights? And a whole host of questions are bundled up in that, but those aren't so much questions about algorithm design in any new sense as they are just regular, quite well established questions of existing law.
Yeah, but you're framing good questions, but what's the answer? What are the answers to these
Well,
problems?
there's no general answer. It depends on the specific type of harm that's being talked about. If it's a harm under competition law, then you'll analyse the relevant liability under competition law. If it's an intellectual property infringement, you'll analyse the harm by reference to IP law.
Well, in the nature of things, we've mentioned lawyers a lot on this programme because it's a legal programme, but are even lawyers safe from the developments in this area? Law and IT expert Richard Susskind, who advises the Lord Chief Justice on such matters, predicts that within 25 years, intelligent computer systems will have taken over much of the work currently done by lawyers.
These machines will learn from their experience. I think it's all highly disruptive stuff, because my view is bespoke human service, the characteristic one-to-one consultative advisory service by lawyer to client, will be exceptional, be terribly unusual by that stage. We will be interacting with systems as though we're interacting with human beings. Online dispute resolution enabled by AI. The systems will be smart rather than hardwired.
So, do you think, Mark and Johnny, I suppose, as practising lawyers, both of you in your own way, do you fear for your practice?
I think it's absolutely correct that we're going to be coming under increased pressure as a legal industry to replace the more formulaic aspects of our role, and certainly technology is perhaps an answer to that in a way of trying to perform and deliver our services in a cheaper and a more efficient way for our clients. I think what Professor Susskind says, though, is slightly unduly pessimistic. I think 25 years is far too long, because we are actually seeing some of these technologies here and now. If you take the litigation process where you have a disclosure exercise, we're seeing predictive coding coming in now, replacing the role of the lawyer in reviewing documents, allowing the technology to do that. The challenge for us, however, is to embrace the technology in such a way that we can perform better and more efficiently, but without removing the fundamental part of what we are as lawyers, the ability to engage with legal reasoning in an emotional, intelligent and commercial sense.
Johnny, the non-lawyer listener to this programme will probably be cheering. It's probably the most popular thing that's ever been suggested on this whole series of this programme, that you might do away with lots of lawyers and replace it with some sort of automatic machine, some sort of procedure provided by Google or whoever.
Well, I wouldn't celebrate just yet. It's all very well to have a machine that can provide answers to our legal questions, but we